Let's get started. Welcome everyone to our third office hours with whistleblower attorneys Renee and Eva. Everyone is in listen only mode. Please type your questions into the Q&A box and you can choose the option to remain anonymous. This webinar is being recorded and the recording will be available on the Fraud Fighters website after this session.
Great. Thank you so much, Q. Hi, Eva.
Hi, Renee.
This is Renee and Eva. We're whistleblower attorneys, and we're here to answer your questions. So we have a big audience today, and folks are already starting to put questions in the anonymous question box, and we're happy to, ask anything. We're here. These are our office hours. This is your chance.
Do we really have a big audience today, or are they all racing to hear the Johnny Depp Amber Heard verdict?
I cannot believe we picked the wrong time to do this, Eva, because as I was just saying, at 3 p.m. sharp, which is happening right about now, the jury is filing back into the courtroom in Northern Virginia, and they're going to render their verdict. So as soon as we hang up on this call, I'm going to find out what happened.
And I will be waiting with bated breath.
Yeah, I wish the timing wasn't that as such, but I think today, Eva, what we were going to talk about, because we've had some advanced questions given to us, and again, we'll keep fielding the questions from folks in the question and answer box. But we, as you know, we get asked all of the time, what kinds of evidence do I need to have in order to, persuade you, an attorney, to represent me? And then for our team to persuade the DOJ to investigate our case and to take, our case seriously. What kinds of hard evidence do we have? So I don't know if you want to address that, Eva, or you want me to address it.
Well, I think you have some really great anecdotes, and I'm happy to talk about it in the context of healthcare fraud. But maybe you can take a first pass, just generally in terms of, what does it mean to have evidence in support of a fraud case?
Right. So, if you think about it, we are bringing a case against a company, often a large company, and we're accusing them of fraud. We're accusing them of wrongfully taking funds from a government program, whether that government program is a government contract or a healthcare program like Medicare or Medicaid, or any, government program. So obviously, a whistleblower can't just show up on the doorstep and say, I have these suspicions, or I know what I'm talking about, take my word for it, right? What prosecutor is going to go ahead and subpoena a major company and say, turn over all your documents, because one person came and told me that they had, strong suspicions, or, that they just, quote, knew that something bad was going on. So what we always talk about it, Eva and we talk about it as you need some hard evidence. And in a fraud case, we're talking about electronic and paper evidence. There's no gun, nobody shot anybody, right? There's no witnesses on the street who watched, the shooting happen or the accident happen. We're talking about companies where employees are communicating with each other electronically on every kind of, electronic format that we now have: Slack, Teams, email. People at companies are creating PowerPoint presentations, and they're communicating and doing their business through electronic means, including sales reps at big companies. We have clients who are sales reps, and most of their evidence is on their cell phone because they're texting their bosses, their colleagues, their doctors that they're, selling to, or what have you. So let's just, even I can just go through a couple of examples, and I will say that if you have any documents from your company, I would bet that they are ones that we want to see. So one of the things that people come to us and say all of the time, every day, every single person says, first phone call is, I don't have any evidence. And then we have a second phone call and we say, you have no emails, no text messages, nothing you brought with you. And they say, well, I did complain to HR.
Well, it's even more nuanced. they don't even, we usually get into a discussion about what they observed that they had concerns about. And in the course of that conversation, they say, well, I emailed so-and-so, and they said that they heard that the physician accepted, $1,000 from this pharma company, or they understood that referrals were being made from another practice. And then all of a sudden, we now have an email that the whistleblower was on and otherwise aware of, and that allows you to appreciate and the whistleblower to understand that email is relevant, because that email has a communication that the DOJ would be interested in seeing to help corroborate that in that case was a kickback that was being offered to a physician, or referrals that may not have been appropriate but being made to the practice. So often it comes in the course of conversation, because as Renee was saying, so many times when a person observes what they believe is illegal activity, they think that their word is sufficient because it's so outrageous. It's kind of like, I just saw pigs fly. I really did. And because it's so mind-boggling, one thinks nobody could think anything other than I'm telling the truth, because it's such an eye-opening, experience that they went through at their former employer. And oftentimes they've been retaliated against because they did raise their hand about these concerns. And to them, to the whistleblower, to the employee, that should be evidence enough that what they were saying is truthful. And while it's helpful evidence, that standing alone isn't sufficient for the DOJ to open an investigation against, as Renee said, these big companies who engage in a lot of government business and accept a lot of government funds.
So one of the things that Eva and I always talk about, and we're often finding it unfortunate that whistleblowers who come to us have come to us after they left their company or after they've been fired, and they didn't first consult with an attorney before they left. And we're always available. So if somebody calls us up at 10 o'clock at night, or reaches our email and says, I think I'm going to be fired tomorrow for, whistleblowing, Eva and I are going to get on the phone with you and have a conversation.
She's already always available. She sleeps with her phone.
But we're both available because we want to give you advice about this documents, taking documents and what you need before they escort you out the door. Or nowadays, now that everybody's working at home, before they capture your computer, take away your password, shut down your access. So it's just critical to try to talk to an attorney beforehand. And almost no one that we've ever spoken with who's a whistleblower is thinking about being one for the first time after they've left their job. They're often raising concerns repeatedly over time within their company. And so it really behooves whistleblowers to seek out an attorney's advice. And most attorneys in our space are going to give you free consultation. They're going to want to talk to you in advance, and they're going to give you some advice about whether or not you might have a case, and that'll actually help you in your decision about whether or not to leave your company, or how to proceed, or how you need to cover your butt. And that's really what we advise people. Like, you have seen something that concerns you. It may be fraud. You've got to cover your butt, right? So you want to take the documents and the evidence and the electronic information that you need to protect yourself and to report your employer to the government.
That's exactly right. And another misconception that we often hear from potential whistleblowers is, well, I know the documents exist, so I can tell the government what to get. It's there. I know it's there. That too is not sufficient. Again, the government is not just going to take your word for it and serve a subpoena, which is a big investigative tool that for publicly traded companies may impose certain reporting obligations that they have under the SEC and to their board and to investors and to shareholders. I mean, it's a big freaking deal to get a subpoena. So and to get a subpoena where one is requesting documents that may corroborate fraud, that's an even bigger deal. So the DOJ is not using its subpoena power willy-nilly, just based on somebody says so. You need to show the DOJ that there is documentary evidence and support for your concerns, and then that really gets the wheels turning for the government prosecutor to engage in further investigative technique.
Yeah, and when we talk about documents, we often find that the first response by folks are, "Oh no, I don't have any documents that are going to be helpful." And then when we explain, you do not need to have a document that says from your employer, "I committed the fraud that you think I did." No one's putting that in an email, and that is not even how you build a fraud case. Even if you had that one email, that's not a big deal, right? When you're talking about a massive company, or any size company, frankly, that's doing business with the government or that's participating in Medicare or Medicaid, to prove a case against any entity, you're going to need to see many communications and documents over time. So even one email, even if it was what people consider a smoking gun in the white collar fraud world, and by that I mean, in the criminal context, we always say that if you come upon a scene and the person, there's a dead person lying there, somebody is standing there with a gun that is smoking and obviously had just been fired, you're gonna, right? That's a smoking gun evidence, because you've got the person standing there holding the weapon over the dead body. That doesn't happen in the fraud world. And one email, even if it was a really hot email that said something that looked like a smoking gun, isn't going to make your case. So that's why really whistleblowers need to understand you need to have more than one document, and it does not need to say, a message from your employer like, "I am guilty of what you're accusing me of," because those don't even exist. Instead, what the government wants to see, and you have to talk about it in every single case, because every case that we have has totally different kinds of documents that are helpful and supportive to the case. But the DOJ and we want to, you have to persuade us first so that we can persuade the DOJ. They want to see the kinds of documents that your company internally keeps on a regular basis. And they want to see some evidence, even if it's not of the fraud itself, some evidence that what you're saying can be corroborated by the documents. And in the context of fraud case, fraud against the government, you cannot build a case without them. You may not have them all at the outset, but you got to have enough for us to be willing to go to the DOJ and say, this person is credible. What they say, part of it is backed up. Other parts of it, they don't have full knowledge. They only have this little piece of the puzzle, and that's fine too, right, Eva? You don't have to have the whole case.
You're never going to have the whole case. Exactly. You're never going to have the whole case, but having a sliver and enough to satisfy all the necessary elements, which is why you need an attorney who can help kind of guide you in terms of what documentation you need to prove your case, it is really essential. It's also important to not think what's relevant and not relevant. So for instance, a lot of persons think many of the documents that they have are innocuous. So easy example, the policies and the procedures on how to do things at the company. Yeah. There are lots of whistleblowers who are like, well, that's garbage. The tutorial on how they told me to, do documentation in the electronic health record system. Nobody wants to see that. That's really pointless. Because it was just like part of my orientation package. It's innocuous. It doesn't seem like it has anything relevant for a fraud case. That piece of evidence is highly relevant because it shows how the company thought it should be doing things. So even a document that's called a compliance manual, or the way in which we should bill correctly, or how we should submit claims to the Medicare or Medicaid programs, those are highly significant documents because they help show knowledge on what the company should have been doing, even if they weren't doing that. It's really a critical piece of evidence. And it's why, at the end of the day, you really do need experts in the field who are able to kind of take a look at everything you have and then identify for you what may be relevant.
Yeah, and also a lot of times people are afraid to take documents from their company. That's when you need to talk to an attorney. There are definite specific allowances for documents you can take and documents you should not take. And there are very specific laws and rules on this, and it depends on whether it's a healthcare case or whether you work for a government grantor or a government or on a government contract. It completely depends on the nature of the documents you need and that you can legitimately take from your employer. So you really should have a prosecutor, former prosecutor, or some attorney like Eva and I who are in the whistleblower space, practicing in the space, who can advise you on what types of documents you should take from your employer to prove your case and ones that you should not.
Right. Renee is raising a really important point specific to healthcare cases. We almost like in every other instance that we are evaluating a potential healthcare case, the whistleblower says, I can't share any patient records with you because those records are protected by HIPAA. And I'll get in trouble personally if I share them with you. And HIPAA, the health insurance affordability, I think I know what the
affordability, I know.
There you go. It's some mumbo jumbo, but it's important. It is intended to protect health records. That's absolutely right. But there's an exception for law enforcement purposes. So when your physician or the pharma company that you're employed by, or the durable medical equipment company or home health company or telehealth company is engaged in fraud, there is an exception in HIPAA that allows you to take those medical records to be able to prove that fraud and share them with your attorney, who thereby will share them with law enforcement or the DOJ. And that's allowable and frankly required in most healthcare cases. So Renee, for whistleblowers who are, really trying to evaluate what kind of a case they might have, how can documents inform, the attorneys and the whistleblower in terms of just the kind of case they have? What can you provide some examples of where a whistleblower comes to you and says, I've observed something really awful, and then when you dig, you realize it's more than that. There's so many layers.
Yeah. I mean, we're obviously spending like this whole meeting, and we keep getting more questions about documents. And this is probably one of the most important things in our space, or bringing a case to us in the initial instance. So it really can't be overstated, but that is really how we vet a case. So our ideal situation, right, is you reach out to us. We have our first initial call with you. We usually do it by a Zoom meeting if you're agreeable. So we can get to know you and you can get to know us, and we want to hear what your concerns are. That's the first question we ask you. It's very open-ended. Tell us what your concerns are. And we listen through those concerns, and frankly, we are trained to sort through what you're saying. So sometimes individuals come to us and they have maybe 5 concerns, and Eva and I are listening to them ask questions, and we can right away tell 3 of those concerns may be a False Claims Act violation. So we're going to focus in on those 3 concerns, and then we're going to talk to you about documents. Are you still at your company? Great, you're still there. You can still get access to documents that are relevant to what you're telling us. Okay, great. You left the company, different scenario. Let's talk about the types of documents that you have. And we know that you have some documents. A lot of people are afraid to tell us on the first phone call, and that's okay. We understand that people are nervous because they don't understand the law yet. They don't understand what it is they can take. But if you can imagine, the government wants and encourages and financially incentivizes whistleblowers to step forward and report fraud in the government. So they also want to encourage proof, right? The government doesn't want to have 2,000 people knocking at their door with claims, and they have no idea whether they're true or not. And so whatever your documents are, we want them all. Just give them to us. We'll have a conversation first, because there's some documents we can't look at and we won't take from you. And that's another conversation, but we'll find out what is the scope of documents that you have, as long as they're documents that we can legitimately see as attorneys, we will then say, dump them on us, and then let us review them, and we'll have our next phone call with you. And then we listen to your concerns. We highlighted 3 of them. We look at all the documents and we say, oh, we have a lot of questions about these documents, and we have another follow-up call. That is how we vet your case. It's through a series of conversations, trying to understand your concerns and seeing what types of documents you have, and to what extent they support your claims. And obviously, some of our clients have amazing documents, spot on documents, exactly what the government needs. Others have not so much, but it also helps. And we have to take into consideration your role in the company, right? So if you are the head nurse at a facility and you are talking about the quality of care that patients aren't receiving, or the types of medication that they are getting that they shouldn't be getting, your day-to-day observation is going to be very helpful, because you're the head nurse at that facility. And so you have a lot of deep knowledge. And so you can maybe, put together a really strong case without as much documents as maybe somebody else who's observing the same things, but maybe they're, in maintenance at the facility, and they don't have that medical knowledge. So that same person coming to us who's in maintenance, who is seeing these concerns that there's not enough staff on the floor, that people are being medicated when they shouldn't be, we probably need more from you, because you're not a nurse and you're certainly not the head nurse. So you're obviously going to have to give us more than that, because you just don't have that expertise and knowledge. So the documents that you have, coupled with your role in the company or the location that your concerns are going to, play off of each other. And so we're going to really evaluate those together. But we're always going to look at the documents, come back to you, have more questions, and then we go from there.
Right.
And it's hard to say, right, Eva, what kind of documents are helpful, because every case is different.
Well, I was just going to say, you took the words out of my mouth. I mean, there's no there's no like metric in terms of like how many you need. So if one were to say, well, how many documents do I need? How many emails? How many policies? I hear you talking about all these different buckets of documents. There's no one size fits all. Just as Renee said, if you are mid-level management or more of an executive at the company where you have the expertise and you had your eyes on everything, and you had knowledge about, more than just your region, you had knowledge of nationwide practices, you're not going to need as much documentary support as someone who was boots on the ground in one city who's trying to allege nationwide fraud, right? They're going to need to have examples that this practice was happening in other states or other locations. And the only way usually to get those examples is in documentation. And so it really depends. Another way to think of this too is the type of fraud that you're alleging. So one example is if you are alleging what's known as telehealth fraud. So telehealth is now a really big business in a positive way. Because of COVID, there were a lot of instances where, actually there was a mandatory shutdown for a period of time where persons could not physically go to the doctor's office, but obviously they still need medical care. And so CMS, the Center for Medicare and Medicaid Services, revived really and expanded what's known as telehealth reimbursement, allowing physicians to provide care to persons in their home using remote technology like Zoom, what we're using now, and even phone calls. And that became a reimbursable service that remains to this day. They've really expanded telehealth services. So if you know of instances where a nurse, for instance, was providing therapy for Medicare patients, but that nurse was never employed by the company. Instead, they either were retired or they had left the company, but the company was still billing under that nurse's number. You frankly don't need as much evidence in that instance, other than to show that the nurse was not employed by that company and was otherwise not seeing those patients. Versus if your allegation is, well, the nurse was only providing half an hour of therapy, but she was billing for an hour. still fraud. That's still, you know, a claim that should not have been submitted and paid for an hour if only the patient only received 30 minutes of service. But you're now having to prove every instance, or at least a handful of instances, where she only provided 30 minutes of care and billed for 1 hour or 60 minutes. So you can see there's just different gradations. And again, that's where you really do need a third set of eyes, a second and a third set of eyes. Renee and I kind of looking at what you have and better understanding the concerns that you were raising to better appreciate whether what you have is enough or whether you need more.
Yeah, and we really try to brainstorm with the whistleblower, because when we, you know, Eva and I were longtime prosecutors enforcing the False Claims Act KETAM statute, and we hate hearing about fraud. So, you know, if we think that you have enough knowledge and credibility, we're going to try to work with you to figure out ways that we can get the evidence that we need. There are other ways that we can get evidence. But we need enough to persuade the prosecutor to start an investigation and subpoena the company. That's what we need. And a lot of people, I can't tell you how many people come and say, well, but can't I just tell them this is what's happening? And can't they just go out and issue a subpoena? I thought that prosecutors could do that. And so the best example that I can think of that like every day people like ourselves can sort of wrap their head around, it's kind of like if you have a neighbor who lives next door to you and you think they're selling drugs out of their house, and you go to the police and say, there's people coming in and out of the house all day long.
Because that's an everyday occurrence for you, isn't it? There's a drug dealer next door. Every
day, there's people coming in morning, noon, and night. The police are going to say, are you kidding? I can't go barge into their house and execute, you know, take all of their, you know, photos of what's going on in there. I can't do that. I need more information. But if you have evidence, if you've like taken a photograph and you have somebody coming to the door and there's a drug transaction, and you have a photograph, but say you only have 2 of those photographs, that may be enough for the police to get a search warrant and to go into the house and conduct the investigation. So of course, I'm talking about criminal cases, not the fraud cases that we do, but it's just sort of a practical everyday example where the police and the law enforcement on the False Claims Act side, they're not going to just go ahead and issue a subpoena to a company based on one person's word, right? That would be troubling for everyone's, from everyone's point of view. They need to have some proof that this is likely going on. And then yes, they will issue a subpoena and they'll conduct a far broader investigation than the little bit of documents that you may have brought to us. But you also, as a whistleblower, need to think, you need to put your thinking cap on, and you need to think creatively about, well, this lawyer told me I need to prove what I'm saying. Let me think how I could do that other than just by my verbally telling them. And, you know, we have folks who are everywhere in the chain of employment, you know, the chain of command at their company. If you have somebody who's much higher level, like say a CFO, or someone who's the head of sales of all, you know, the company's regions, that person may need less documents than someone else, right? Because they are in the seat of knowledge. And so they actually can testify to everything that's happening at the company with regard to the concerns that they have, versus somebody who is one person in one small office of this major company. Though that person might need more documents, because frankly, we don't know that what they're saying is company wide, right? So, you know, we want to go to the DOJ only with credible information. And you want your lawyer to be that way. You can always find a lawyer who will file anything, right? We all probably know lawyers like this who will file anything, but the next time they file something, they're going to be suspect, right? The DOJ is going to be like, oh yeah, that last time they just filed something and it had no merit. So you want a lawyer who has credibility with the DOJ, somebody who, when the DOJ gets their complaint and their information, says, oh, this is a lawyer who brings only good, well-vetted, well-proven cases to me. I'm going to take their claim serious. So Eva, do you see the next question in the queue? Let me ask it to you.
Yeah.
So what if I'm new to a company and I think I've observed some possible fraudulent activity, or I believe that the company's policies are lacking. Do I have to be at the company for an extended period of time in order to be a valid whistleblower and report my concerns? How long do I have to be at a company?
It's a great question. That's a great question. There is no time frame on this. It really, we have plenty of instances where whistleblowers, successful whistleblowers, have only been at the company for less than a year, maybe just even a handful of months. But in that time, because of their expertise in the field, they immediately catch on that the company is engaged in fraudulent activity. They immediately download whatever documentary evidence they have, and they confront their management with that evidence, and they're canned effectively. And if that happens in the course of 2 months or 2 weeks, if you have observed fraud and you have documentary evidence of that, you may have a fraud claim against your now former employer. It really doesn't matter that you were only there for 2 weeks or 2 months, 2 years, or 20 years. It kind of matters not to some extent. Now, of course, logic dictates in favor of, if you were there for an extended period of time, you may have more observations and more knowledge, but not always, because there comes a point where a whistleblower who has been there for a long time all of a sudden comes to a realization that what they may have been doing all along was wrong. And it's only at that time that they begin to gather the necessary evidence or just memorialize their concerns. And that's another piece of documentary support that can be helpful, is memorializing in real time, like memo to file or memo to yourself, a meeting that you just had. If you're able to do contemporaneous notes where you confront your manager with certain, improper activity or certain suspicions that you have, that can be enormously helpful because there's some credibility that attaches to your contemporaneous notes. There's a whole nother discussion that we can do on audio recording that we'll save for another conversation. You want to be careful with tape recording conversations, and it depends largely on what state you're in and what state the others are in for whom you may be recording activity. So we're not necessarily going to encourage that, but contemporaneous note taking is great and something that you should certainly do.
Well, I think we've come to the end of our time. So we thank you. And I think we've answered all the questions today. And thank you for joining me and my partner, Eva. For office hours, we will have office hours again next month. So please bring your questions and we're happy to answer them. Thank you.
Thanks so much.
Thanks for joining us.